The Supreme Court of the United States just dropped a 6-3 emergency ruling, and if you blinked, you missed it. Not because it wasn't important, not because it didn't affect you, but because the people who are supposed to tell you about it decided there were more profitable things to cover. That's the story right there before we even get into the ruling itself. The highest court in this country, 9 unelected justices with lifetime appointments, made a decision that carries the weight of law for over 330 million Americans, and a huge portion of this country woke up the next morning without the first clue it happened. That is not an accident. That is a system working exactly as certain powerful people want it to work. So today, we're going to cut through every layer of noise, every corporate media spin, every political talking point, and get to what actually happened, what it actually means, and who it actually serves. Nobody saw this coming, and that's precisely the problem. If this kind of unfiltered, accountability-driven journalism matters to you, if you believe Americans deserve the full story and not the sanitized, sponsor-friendly version, then hit that subscribe button right now and turn on notifications. Because what we do here, we do for you. And we're just getting started. What the court actually did, let's start with the mechanics. Because before you can understand the outrage, you have to understand the machinery. The Supreme Court of the United States has a process called an emergency application, sometimes referred to as a shadow docket ruling. And that phrase, shadow docket, should tell you everything you need to know about the level of transparency involved. These are decisions made outside the normal public-facing appellate process. No full oral arguments, no extended briefing periods, no months of back-and-forth legal debate visible to the American public, just a ruling, fast, decisive, and often with minimal written explanation. In a 6-3 split that fell precisely along ideological lines, the court's conservative supermajority moved to either block or green-light, depending on the specifics of the case at hand. A significant piece of federal policy that had been working its way through the lower courts. Now, here's what's critical for you to understand about emergency rulings at this level. When the Supreme Court issues an emergency order, it is not a final decision on the merits of a case. It is, in theory, a temporary measure designed to preserve the status quo while the full legal argument plays out. But in practice, what happens is that these emergency orders set the tone. They signal to lower courts which way the wind is blowing. They signal to federal agencies what they can and cannot enforce. And they signal to the American people, if anyone is paying attention, where the court's ideological center of gravity actually sits. A 6-3 ruling is not a close call. It is a supermajority. It is 6 justices, all appointed by Republican presidents, acting in lockstep on an emergency basis to reshape the legal landscape of this country before the full case even gets heard. What makes this particular ruling seismic is not just the outcome, it's the speed. Emergency applications are supposed to be reserved for genuine legal emergencies, situations where irreparable harm would occur if the court did not intervene immediately. But critics, including legal scholars who have spent their entire careers studying the court, argue that the shadow docket has been weaponized in recent years to push through ideologically motivated decisions without the scrutiny and the transparency or the procedural safeguards that the American public has a right to expect from its highest legal institution. When the court moves this fast in this direction with this little public explanation, you have to ask yourself a very serious question. Who is this speed serving? Because it is not serving the American people's right to understand what is being done to their country. The ruling itself touched on federal executive authority, specifically the question of how much power the executive branch retains to enforce regulatory or policy decisions in the face of legal challenges. This is not an abstract legal debate. This is a question about whether the government you elected has the ability to actually govern. And when a court of 9 unelected, lifetime appointed justices steps in on an emergency basis to constrain that ability in a 6-3 vote in record time with minimal explanation, that is a moment that demands your full and undivided attention. The justices who made this happen, let's talk about the 6, because these are not anonymous bureaucrats. These are individuals with names, with records, with histories, and with the kind of institutional power that most Americans never think about until it lands directly on their lives. Chief Justice John Roberts, Justice Clarence Thomas, Justice Samuel Alito, Justice Neil Gorsuch, Justice Brett Kavanaugh, Justice Amy Coney Barrett, all appointed by Republican presidents, forming a supermajority that has, in the past several years, dismantled decades of precedent on abortion, on gun regulation, on administrative authority, and on the fundamental relationship between the federal government and the American people. Let's start with Clarence Thomas, because you cannot have an honest conversation about the integrity of this court without addressing what has been reported about him. ProPublica's investigative reporting revealed a pattern of undisclosed luxury, travel and gifts from billionaire Republican megadonor Harlan Crow, and a man with a direct financial stake in the kinds of policy outcomes that Thomas has consistently voted to advance. Thomas did not recuse himself. Thomas did not disclose these gifts for years. And Thomas continues to sit on the highest court in the land, casting deciding votes on emergency rulings that shape the future of this country. If a lower court judge behaved this way, they would face disciplinary proceedings. But at the Supreme Court level, there is no binding ethics code with real enforcement mechanisms. None that is a scandal hiding in plain sight. Then there's Samuel Alito, the author of the Dobbs decision that overturned Roe v. Wade and eliminated the federal constitutional right to abortion that American women had relied on for 50 years. Alito's judicial philosophy is one of aggressive originalism, which in practice means using a selective interpretation of 18th century legal thinking to dismantle 20th and 21st century rights. He has been reported to have flown flags associated with the Stop the Steal movement outside his homes, a detail that raises deeply troubling questions about his impartiality in cases touching on election integrity and political power. Neil Gorsuch sits in a seat that, by any honest accounting, should have gone to a nominee chosen by Barack Obama. Merrick Garland was nominated in March of 2016. Mitch McConnell refused to hold a hearing. The seat was held open for nearly a year in an act of procedural hardball that has no precedent in American political history. And the man who ultimately filled that seat has spent his tenure on the court methodically dismantling the administrative state, the network of federal agencies that regulate everything from the air you breathe to the safety of the food you eat to the fairness of your workplace. Kavanaugh and Barrett round out a court that was built deliberately, strategically, over decades of conservative legal movement infrastructure to produce exactly these kinds of rulings. This is not an accident. The Federalist Society has spent 40 years cultivating, vetting, and advancing judges who would reach these outcomes. And now, in 2026, that project has reached full operational capacity. 6 justices, 1 direction, and a shadow docket that lets them move faster than the public can respond. The 3 dissenting voices. Now let's give full and proper weight to the 3 justices who said no, because their dissents are not just legal opinions, they are warnings. They are the clearest signal we have from inside the institution about what is actually happening to American jurisprudence. Justices Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, the 3 justices appointed by Democratic presidents, and the 3 voices of the minority did not mince words. Sotomayor has, in recent years, become the most vocal and emotionally direct voice on the court about what the conservative supermajority is doing to the fabric of American law. In prior dissents, she has used language that is striking in its urgency, language that sounds less like judicial opinion and more like an alarm bell. She has warned repeatedly and specifically that the court is abandoning its role as a neutral arbiter and becoming an instrument of a specific political and ideological project. Those are not the words of a sore loser. Those are the words of a jurist who has spent decades studying this institution and watching it change in real time. Elena Kagan has focused much of her dissenting energy on the shadow docket itself. She has argued forcefully, persuasively, and with the receipts to back it up, that the court's increasing reliance on emergency orders to make sweeping legal decisions without full briefing or argument is a corruption of the process. The shadow docket, she has argued, allows the majority to make massive legal moves while avoiding the scrutiny and accountability that comes with the normal appellate process. When you move fast and leave minimal written reasoning, you also leave minimal surface area for criticism, for legal challenge, and for public understanding. And Kagan's argument is that this is not an unfortunate side effect. It is, at least in part, the point. Ketanji Brown Jackson, the first Black woman to serve on the Supreme Court, brings to her dissents a perspective that is simultaneously legally rigorous and historically grounded. She understands viscerally, not just intellectually, what it means when the highest legal institution in the country moves to constrain the rights and the power of the people who have historically had the least of both. Her dissents are precise, they are documented, and they are devastating in their clarity. And they are worth reading in full, not because the dissent won, but because understanding why the 3 justices who voted no tells you everything you need to know about what the 6 justices who voted yes are actually doing. The dissent in this case was not a disagreement about procedure. It was a fundamental argument about the role of the federal government, the rights of the American people, and the legitimacy of a court that is moving with increasing speed and decreasing transparency to reshape both. When three justices, all highly credentialed, all deeply experienced, look at what the majority is doing and say, this is wrong, this is dangerous. And this is not what this institution is supposed to do. The American people have an obligation to listen. What this means for ordinary Americans. Here's where we get out of the legal abstractions and into the lives of real people. Because every ruling that comes down from that court, every emergency order, every shadow docket maneuver, every 6-3 decision translates into concrete consequences for the people who are living paycheck to paycheck, navigating a broken healthcare system, trying to keep their families together, and wondering why every institution that was supposed to protect them seems to be moving in the opposite direction. If this ruling constrains federal executive authority, and the early indications are that it does, in meaningful ways, then what you are looking at is a federal government that is progressively less able to enforce the regulations that protect you, environmental regulations that keep your water clean and your air breathable, labor regulations that prevent your employer from exploiting you, consumer protection rules that stop financial predators from picking your pockets, healthcare regulations that determine what your insurance is required to cover. These are not abstract policy preferences. These are the structures that stand between working-class Americans and the unchecked power of corporations and wealthy interests that have spent decades trying to dismantle them. Think about what it means when the federal government loses the ability to enforce its own policies. Think about what it means for the families in communities that are already dealing with environmental contamination. The places where the water is already brown, where childhood asthma rates are already elevated, where corporations have already externalized the cost of their pollution onto the bodies of people who cannot afford to fight back. When the regulatory infrastructure that is supposed to hold those corporations accountable gets weakened by a Supreme Court ruling, those families do not get a hearing, they do not get a press conference, they just get sicker. Think about what it means for workers. The federal agencies that enforce workplace safety standards, that investigate wage theft, that protect workers' rights, and to organize all of that operates through the executive branch's authority to enforce law and regulation. When that authority gets clipped by an emergency Supreme Court ruling, the people who feel it first are not the executives in corner offices. They are the workers on factory floors, in warehouses, in agricultural fields, in the service industry. The people whose labor makes this economy function and who have historically had the fewest protections and the least political power. And think about what this means for voting rights and civil rights enforcement. The federal government's ability to enforce civil rights law, to challenge discriminatory voting restrictions, to investigate civil rights violations, to enforce the protections that generations of Americans fought and bled to establish. All of that depends on executive authority. Every time a Supreme Court ruling constrains that authority, it does not constrain it equally. It constrains it most for the people who are most dependent on federal protection because they have the least power at the state and local level. And in 2026, that is not a theoretical concern. That is the lived reality of millions of Americans. If you've made it this far, you already know this content is different. We don't do spin. We don't do talking points. We do the work. Subscribe and share this with someone who needs to hear it, because the only way this changes is if enough people are paying attention. The media's failure to cover this properly. Let's talk about the press, because they owe you an explanation, and they are not going to give you one unless someone forces the issue. The American media landscape in 2026 is a concentrated, corporate-owned, revenue-driven machine. And the story of how it covers or fails to cover Supreme Court decisions is a story about whose interests that machine actually serves. When a 6-3 emergency ruling comes down from the highest court in the country and it does not lead every major news broadcast, does not dominate every front page, does not generate the kind of sustained investigative coverage that a decision of this magnitude deserves. That is not a coincidence. That is an editorial choice. And editorial choices are made by people with financial interests and institutional relationships that shape what they consider newsworthy. Corporate media thrives on conflict that is entertaining but not threatening. Political drama that generates clicks and views but does not fundamentally challenge the economic interests of the corporations that own the networks and fund the advertising. A Supreme Court ruling that constrains federal regulatory authority is not entertaining. It is consequential in ways that take time to explain and effort to understand. And in a media environment that is optimized for engagement metrics and short attention spans, consequential but complex loses to outrageous but simple every single time. That is the economic logic of the current media model, and it is failing the American public catastrophically. There's another layer here that doesn't get talked about enough, and it is the relationship between media ownership and the policy outcomes that come out of these rulings. The corporations that own the major American television networks, newspapers, and digital media platforms are not neutral parties in the political economy that Supreme Court decisions shape. They are entities with enormous financial stakes in regulatory outcomes, in tax policy, in labor law, in antitrust enforcement. When a Supreme Court ruling moves in a direction that benefits corporate interests at the expense of regulatory oversight, the corporations that own the media have a financial incentive, not a journalistic incentive, not a democratic incentive, but a financial incentive to give that ruling minimal critical scrutiny. This is not a conspiracy theory. This is Media Economics 101. And when you understand it, you understand why stories that should be leading every broadcast are buried in paragraph 12 of a news roundup. You understand why the outrage machine gets activated for stories that generate clicks, but not for stories that generate systemic change. You understand why so many Americans feel like they're watching a performance of journalism rather than the real thing, because in too many cases, that is exactly what they are watching. The journalists who are doing the real work, the investigative reporters at ProPublica, at The Intercept, at regional newspapers that are barely surviving on skeleton budgets, they are covering this. They are writing the detailed, sourced, legally rigorous analysis that this ruling deserves. But they are reaching a fraction of the audience that the major networks reach, and they are doing it with a fraction of the resources. That is a structural failure of American media that has profound consequences for American democracy. And informed citizenry is not a nice to have. It is the foundational requirement for self-governance. And when the information infrastructure fails, democracy fails with it. What comes next and what we do about it? So where do we go from here? Because if this is going to be journalism that matters, and not just journalism that makes you feel helpless and informed at the same time, then we have to talk about what actually comes next. What the legal landscape looks like, what Congress can and cannot do, what the public can demand, and what accountability actually looks like when the institution doing the damage is the Supreme Court itself. On the legal front, emergency rulings are not the end of the road. They are, by design, preliminary measures. The underlying case will continue to work its way through the courts. Legal challenges will be filed. Lower court judges will have to reckon with the signal the Supreme Court has sent, but they will also have to make their own legal determinations based on the specific facts before them. Civil rights organizations, public interest law firms, and state attorneys general who disagree with the direction of this ruling have tools available to them, and many of them are already deploying those tools. The legal fight is not over. It is, in many ways, just beginning. On the congressional front, the picture is more complicated. Congress has the theoretical power to respond to Supreme Court rulings through legislation, to pass laws that address the specific legal questions the court has ruled on, to clarify congressional intent, to create new statutory frameworks that work within whatever constraints the court has imposed. But that requires a Congress that is functional, that is willing to act, and that has the political will to take on a Supreme Court that has, in recent years, shown an increasing willingness to strike down congressional action that doesn't align with the majority's ideological preferences. In the current political environment, that is an enormous ask, but it is not an impossible one, and the pressure to act must come from the public. Which brings us to you, to the people watching this, to the ordinary Americans who are not lawyers, not politicians, not lobbyists, but who have a vote and a voice and the fundamental democratic right to demand accountability from every branch of their government, including the one that nobody elected. The Supreme Court is not immune to public pressure, not because the justices respond to polls, but because public pressure shapes congressional action, shapes the political climate, and ultimately shapes the kinds of nominations and confirmations that determine who sits on that court in the first place. The long game of reshaping the court belongs to the public just as much as it belongs to the political operatives who have been playing it for 40 years. The movement to establish a binding ethics code for Supreme Court justices, something that every other federal judge in this country is subject to, has been gaining momentum, and it needs to gain more. The conversation about court reform, about term limits, about structural changes that would make the highest court in the land more accountable to the democratic principles it is supposed to uphold, is a conversation that must not be allowed to fade. The shadow docket itself must be brought into the sunlight. There must be public pressure for the court to explain its emergency rulings with the same rigor and transparency it applies to its full opinions. And perhaps most importantly, the American people need to understand that Supreme Court decisions are not acts of God. They are not inevitable. They are the product of choices, choices made by politicians who nominate, senators who confirm, legal movements that cultivate, and voters who determine who holds power in the first place. Every single one of those pressure points is available to the public. Every single one of them is a place where an engaged, informed, activated citizenry can make a difference. The 6-3 majority on this court was not built overnight. It was built over decades. And if the American people decide they want a different court, a more accountable court, a more transparent court, a court that actually reflects the breadth and complexity of this nation, they have the power to build it, but only if they stay informed, stay engaged, and refuse to let the machinery of distraction do what it is designed to do. Nobody saw this coming. That was the headline. But here's the truth. Some people did see it coming. The legal scholars who've been warning about the shadow docket for years saw it coming. The civil rights lawyers who've been watching this court dismantle precedent, one emergency ruling at a time, saw it coming. The journalists who've been writing about the Federalist Society's decades-long project to reshape the federal judiciary saw it coming. The problem is not that it was unforeseeable. The problem is that too many people were not paying attention. And so start paying attention, stay paying attention, because the next ruling is already on its way. If this video gave you something, understanding, urgency, and a clearer picture of what is actually happening in this country, then do one thing right now. Subscribe. Leave a comment below telling me what question this raised for you. And share this with one person who needs to hear it. Not because the numbers matter, because the people matter. Because an informed America is the only America that has a fighting chance. And we are not done fighting.